Any mention?
Yes, yes, who's that? Yes.
I mentioned item number 45, Your Lordship.
Yeah.
Your Lordship, this matter can be adjourned and taken up 2 weeks, Your Lordship. The conducting counsel could not act because of personal difficulty, Your Lordship. It is
45.
No objection, Your Lordship.
Yes, sir. Yes, Your Lordship.
3 weeks. Yes.
Lordship, I beg to mention item number 42, Lordship.
42?
Yes, Lordship. Counsel is from Guwahati, Lordship. He could not come.
Doesn't matter. From Guwahati, then you do it.
Yes, Lordship.
No concession.
And no-
Therefore, excuse saying we will
no
come.
local counsel here
Okay,
also.
we'll hear it today only.
So no local counsel here, Lordship. That local
Then
counsel.
who are you then?
I'm just on his behalf, Lordship.
3 weeks. Yes.
Hello.
That's no excuse. No. Council Guwahati. Why Council Shillong not important? Did Council Guwahati take precedence over Council Shillong?
His case, Lordship, because he there.
Yes.
Yeah, please, Your Lordship. Lordship, I beg to mention to item number 29.
Why?
Your Lordship, the conducting counsel is out of station today, Your Lordship.
You sure about that? Mr. Kurish is out of station?
Yes, Your Lordship.
Yes, 1 week.
Highly Lordship.
Name, please, Your Lordship.
Yes, yes. Yes. But bhai ba mo but bhai say pick up bhai no. Yes.
Lordship, I beg to mention item number 28, 37, 38 and 39. The engaged counsel be parted with some personal difficulty.
20? Yes, come again.
37,
37, 38, 39,
39.
3 of them.
Your Lordship, 36 is also a connected matter here, Lordship.
36. Who's for petitioners of 36?
Lordship M. Chandapur.
Why? What's the difficulty? Who are the other counsels there? Mr. V. Kumar is there.
Lordship B.B. Kumar is out of station to his hometown.
Okay, 2 weeks. With the personal difficulty of the Mr. B. Pathak Clinical Counsel is also submitted. Item 36 is connected with the matters. That's it together with the 37, 39 for 2 weeks. Yes. You inform Mr. Chanda.
Your Lordship.
Yes.
Much obliged.
Your Lordship, I beg to mention item number 47, Your Lordship.
Monday morning, I'm mentioning. Yes.
Let it come out of 2 weeks, Your Lordship.
Lordship, I have some objections to this matter, Lordship.
Why?
Lordship, this is a stay order and...
For the stay order?
Yes, Lordship,
What's the
there's
matter
no
about?
case.
Regularization.
Of case, Lordship.
What's the matter about?
It's regarding regularization, Lordship.
No, why is there stay order and regularization?
Lordship, when the matter was going on, the petitioner was terminated. So, Lordships had passed a status quo order in this matter, Lordship.
Okay, then.
And
So when we want it, we'll have it this week only?
Let it come after 2 weeks or next week, Your Lordship.
Okay, after 1 week, so 23 matter. Yes.
Obliged.
Your Lordship, I beg to mention item 40.
Number?
40. 40.
40.
Yes, Your Lordship. No objection, Your
Yeah,
Lordship.
objection.
No objection, Your Lordship, but I pray that my salary may be released, Your Lordship. I'm finding financial
You're
difficulty.
for managing committee.
Yes, Your Lordship. Respondent number 5.
Are you ready with the matter today?
My senior is ready, Your Honor, but the counsel from the other side, he informed that he's in Delhi.
I am from the state.
You ready?
Yes, nothing is there.
What is your role?
Your Lordship, the counting counsel is out of station.
Mr. Changraiso?
Mr. Piobin.
We can't have this. No, if a person is getting a salary, we can't just adjourn the cases. like indiscriminately. We'll have for 1 week.
After 1 week.
Yes.
Duly obliged.
May it please, Lordship. Lordship, I beg to mention item 41, Lordship. Lordship, we require some more time for this matter. So kindly have this matter after 2 weeks, Lordship.
Why?
Lordship, we require so much time.
What's the matter about?
Lordship, this is with regard to the illegal taking over the land of the petitioner. Lordship.
2 weeks, okay.
Highly obliged, Lordship.
Item number 1.
Please, Lordship. This is the petitioner. He is the wife of the deceased employee. He is coming for payment of gratuity, Lordship, because the monthly pension they are releasing, but only the gratuity and that is remaining, Lordship.
Pension receiving.
Pension receiving monthly.
Yes, who's appearing?
I'm appearing for respondent 1, 2, and 4. MTC.
Mr. P.T. Sangma, are you sure you're not getting gratuity?
Lordship.
Where
Lordship,
you see? Where you see you haven't got it?
I have not. I have that annexure 5, Lordship. Annexure 5. That amount they have given the 9,53,654, and another amount, Lordship. It is annexure 6.
No, are you sure you have not got this amount?
No, Lordship. Lordship, I have not received this amount.
We have to get instruction.
Lordship, in this case, actually, we've been wrongly arrayed as a party here, because MTC employee does not fall under the ambit of MCS pension rules.
Strike you off.
Yes, Your Lordship.
Yes, sir. Mr. P.T. Sangma, Council Petitioner, issue notice of Mr. A. Moomin is pen accept notice on behalf of respondents 1, 2, and 4. Stop. Mr. K. Karwana, who is present, submits that the respondent number 3 has been wrongly arrayed as a party, as much as the Accountant General has nothing to do with the respondent corporation. He prays that the Accountant General be struck off from the array of parties. Next issue notice. Stop. All authorities sorry, except also Mr. A. Moomin prays that allowed to obtain instructions within 3 weeks. Yes. As submitted by Mr. H. Kanoplang. Respond number 3 to be struck off from the area of parties in the red petition. So this amount for 2 weeks for instructions affidavit.
Highly obliged.
Much less, Lordship.
Item number 2.
May I please, Your Lordship? Your Lordship, here the petitioner is claiming for family pension. The petitioner's husband was working with respondent's university as driver, Your Lordship. Thereafter,
as a driver?
As a driver, Your Lordship. Thereafter, he retired in the year 2010. Your Lordship, he was getting his pension until his demise in the year 2018. After his demise, Your Lordship, we conveyed the same to the respondents.
So you asked for family pension. Yes, Mrs. Sen.
But they have asked for, their prayer is to dispose of a representation.
And also, for releasing of family pension, Your Lordship.
Yes.
And also for releasing of family pension.
No, representation. Where's the representation?
Representation.
Page 19. Page 5. Election 5.
Page 19, Your Lordship.
You dispose her off. She's an old lady, 65 years old. We'll dispose her off.
Representation, yes. Just the Lordship will pray, my Lord, sometime, 3 months' time at least, my Lord.
Not 3 months. We'll do it within 2 months is more than enough. The petitioner is before this court for a direction for release of family pension. for the frank pension, or at least the frank pension stop. It is submitted that the husband of the petitioner, who has since deceased, had retired from the services of the respondent university on 31/10/2010, and after retirement was in receipt of monthly pension till his death on 25/1/2018. MSP Chetri also submits that the fact of the demise of the petitioner's husband was duly informed to the respondent university, and a representation was also made on 21/8/2023, which, however, has evoked no response till date. She therefore prays that sanctions be issued to the respondent university for disposing of the representation and for release of the family pension as entitled. Next paragraph. Mr. S.N. Leonard Counsel on behalf of the University submits that as there is a matter concerning payment of family pension, the respondent university will dispose of the representation expeditiously as possible. Next, by considering submissions made by the counsel of the parties, this petition is disposed of at the motion stage itself by directing the respondent university to dispose of the representation dated 21/8/2023, which is annexed Lecture 5 to the writ petition, within a period of 2 months from today. They expected thereafter that if there is any entitlement, these due amounts be cleared immediately thereafter, be allowed.
No, Lordship, only let the university dispose of. If she is, and because I am not saying other thing, she is facing trial, yes. CBI trial. Pension is subject to. That's why I am not saying much more.
Your Lordship, here I would like to submit. The CBI trial is completed, Your Lordship.
CBI, they are facing trial.
Yes.
She was
this lady.
It's completed, Your Lordship.
Trial.
Yes, Your Lordship. But it's completed, Your Lordship.
She was holding 2 posts, suppressing facts.
This same Prakash Kaur.
Yes. That's why I'm not saying. Let it be disposed of. If she is entitled, she will get.
She is entitled by virtue of this.
We should not comment on this.
Yes.
Your Lordship, it is the admitted.
As directed above, matter stands disposed of.
Lordship.
Item number 3.
Well, this matter relates to seeking for trading license from the respondent district council. Petitioner has entered agreement with the landlord. Page number, my lord, 22, tenancy agreement. Page 22 of the petition. 22, my lord.
With a landlord?
The landlord, my lord. Tenancy agreement. End of 24th November 2022.
Yes.
My lord. And thereafter, my lord, page number 24, I received the show cause from the licensing officer to close down the shop, stating that, my lord, I don't have the trading license. He has given me 15 days, my lord. And thereafter, my lord, I came up with the application. Initially, I had the application.
No, first, you refer to agreement. What agreement is this?
Tenancy agreement.
What does it say?
It's a tenancy agreement.
Or get a tenant.
Tenancy. I'm the tenant. Yes.
Okay, then.
I'm the tenant only. It is for 1 year.
You don't have a trading license.
I don't have a trading license. When we entered this agreement, the building owner given me the impression that she will obtain the trading license from this council. So we entered agreement and I opened the shop.
When agreement she said that she'll
my lord, it is not spelled out.
Then how do you say that?
My lord. But thereafter, my lord, I received the show cause, my lord.
So the agreement has to have no meaning, that means?
My lord, the tenancy life of the agreement is there. With regard to that trading license.
You might have a tenancy, that means, but without trading license, you won't be able to operate.
Yes, yes. That condition is not there immediately. I concede with that point.
Right.
And secondly, my lord, page number 24, the show cause notice issued by district council.
Yes.
And thereafter, my lord, realizing that, my lord, I came up with the application before district council. Page number, my lord, 25-26. detailed applications. Page number 26. This is the form under the rules. Applied for this, and I have accompanied the recommendation of the headman, page number 30. That is under the rules, under the Act. Page number 30. Well, and page number 32, even my landlord has given me the certificates that obtained the NOC. Yes. Page number 32.
Yes.
Well, and I approached the respondent mediumship, in fact, to give me the NOC, since the district council insisted for that. But the mediumship did not respond, but rather they asked a huge exorbitant amount of money.
Why mediumship?
My lord, the district council directed me to approach the mediumship to obtain the NOC. Accordingly, thereafter they can grant me trading license. So I approached before this mediumship. Mediumship did not say I don't have authority. They said that you bring some fees, which is exorbitant to the writ petitioner. Because of that, my lord, he came up with the RTI application before district council and this mediumship. My lord, page number 35 is my RTI application, 35 to the district council. My lord.
Yes.
And point number 7, the lordship, kindly see. What is the requisite fee required to be paid for the obtaining NOC by the non-tribal from the office of the sons and such? They insisted for that. Now, the reply was given to me, page number, my lord, 37. And the 11th portion would be my page number 38, point number 2. He answered, my lord, whether no objection certificate for obtaining trading license for non-tribal is mandatory from the office of Milliam. Kindly mention
Where
the rules.
Where does it say that? Show the
my lord, the rule is very clear.
Has to give
it is not given.
I think it's the headman or citizen.
My lord, lordship, kindly turn to page number, second volume, page 247, regulation
247.
My lord. And lordship, kindly see rule 3A.
1 second, give me time. You're not as fast as you. Two?
Rule 3A.
Oh,
page number, my lord, 247. 247.
Part 1, not part 2.
This will be part 1, my lord, of the council compilations.
Yes.
My lord, lordship, may kindly take to rule 3A, conditions for granting or refusing a license. And lordship, may kindly see the relevant portion would be sub-rule E, my lord. E would be relevant, my lord. Whether the application has been recommended by the village headman after being approved by the local Darbar. So that is, we have a next in the application itself.
Why
so this is the only requirement.
Asking from same Milliam?
I also don't know, lordship. I'll take instruction.
You take instruction
because
the Act doesn't say
under
that.
the Act rule doesn't say that matter from
even in that Sora matter, I would pass the judgment, which correct the earlier judgments also. I mean, like the earlier, because of this court, some the deputy commissioner said go to CMs and that. So
I'll take instruction.
Yes. You have the interim prayer?
No interim prayer, man. A shop is
Special Commissioner Council with so and so for the petitioner issue notice. Mr. VGK Kinta, the Senior Counsel for is present on behalf of the respondents 1, 2, and 3. No further notice called for on these respondents. Should we issue to pro forma now?
I don't if lordship.
Yes, notice. Steps to be taken for such notice of profound respondent within 3 days stop. Mr. Vijita submits that appraise that he made out to obtain instructions in the matter. I'll call this a matter after
2 weeks.
2 weeks, yes.
Much order.
Item number 4.
Please, Your Lordship. This is that matter, my lord, concerning the non-release of allowances to the employees of Muda, my lord. On the last occasion, my lord, the learned friend had sought time to obtain instructions.
No, last time you didn't say where they're working or what was the engagement.
We had already done the needful in terms of Your Lordship's last order. Corrected.
Record keeper, process server. process server, designation, tracer, SA. They all working?
Yes.
Yes, Ms. Nongri.
My lord, if this matter can come up for admission hearing, my lord, we'll place Jagjit Singh and my lord, and point out that we have complied with the judgment. Then nothing will survive, my lord, because the temporary employees, in terms of Jagjit Singh, we have complied, my lord.
But the interesting issue here is, my lord, here these employees were very much paid the allowances earlier. It was discontinued without any reasons whatsoever, my lord. So to that extent, they owe an explanation as to why.
You come prepared. He's already given you a clue which judgment he used.
Okay.
So yes, as directed by this court, the cause title has since been corrected, indicating the designation of each of the designation and engagement of each petitioner. Parties praise the matter with for admission hearing, or Mr. Firam Nongri on behalf of the responsible for praise that the matter is admission hearing. Stop. Prayers allowed. This matter when?
2 weeks, my lord. In the meantime, my lord, if I can resolve the matter, I'll try my.
So you're not filing affidavit?
Not required, my lord. Legal point.
So matter for admission hearing. Stop.
Deeply.
All right. Yes.
Item number 5.
Lordship, this matter can be listed along with second appeal number 1 of 2023.
We'll do one thing.
The issue
We'll
of the
pass on
same.
judgment. Let it go back to Supreme Court. I think better. Yes. Caveat.
The other matter is already put on 6. So perhaps this matter can be taken up on 6 along with the other matter.
Let's finish off your caveat first.
Yes.
Caveat petition 126/2023. Seen the caveat petition. Caveat is presented by MS B. Sharma Goel and Mr. S. Thapa. Yes, the same stance is charged. Next on the main case, this matter being similar and identical to, that's what other number?
Second appeal number 1 of 2023.
Yes, A1 2023. That's the same for together for admission hearing on 6 October 2023. Yes.
Much obliged.
In the meantime, I have perhaps since it will be coming up for admission hearing, formal notice if required may be issued, and since we are already
no need. Formal notice is dispensed with, since you already appear by you already in caveat.
There's a status quo order, my lord, in the other case. Even if that continue, because
yes, a status quo orders to operate. Yes, in the meanwhile. Status quo to maintain the meanwhile. Yes.
Item number 6.
Too close.
On 28/7/2023.
Yes, Mr. Dr. Saraf.
On 28/7/2023, she directed the respondents to file an affidavit on merits.
Yeah, they filed it. Why?
28 for time. And again today, the message coming, they are not filed an affidavit.
What should also should impose cost?
But in fact, the matter you are just saying, the matter is that the Director of Industry and Commerce of Meghalaya sought for certain clarification from the Government of India. Now that clarification has been given. There is nothing like we are not seeking for that the amount of the merits. The clarification has to come.
Yes.
Now they are not issuing a clarification, in spite of repeated reminders from the Director of Industry and Commerce.
Let them file an affidavit, Dr. Saraf. Then let them file it and we'll dispose of the next date. How much time for the time you require?
4 more weeks.
4 more weeks. Why? Because the issue in question is very small. It's not.
4 weeks.
Mr. Dr. M. Mosikala, DSGI submits that due to unavoidable circumstances, the affidavit could not be filed. He praised that as a final opportunity, he be allowed 4 weeks' time, feeling which the matter decided on its merits on the basis of materials that are available on record.
But that may not kindly.
Why not? That might compel you to file the affidavit.
My lord, a short affidavit you already filed, my lord. After hearing that, my lord, that was only
Okay,
in the month of July.
Form number. Yes, Honorable. Allow stop. In consideration thereof, this is matter of 4 weeks as a fixed item. It's understood that on the next date no further adjournments shall be taken. Yes.
It comes to the same thing.
Comes same thing. But I'm not putting in those words. That's all.
Item 7.
Mr. Demda, I'm not allowing you any more time.
Your Lordship, in these matters,
before you make a prayer also.
Your Lordship, this affidavit was ready, and after this was a present status of this were not inflected. So this.
I do not understand.
Your Lordship, this payment has been made. So from the Deputy Commissioner, we are supposed to collect this information, whom they have given and how much given. All
That's
these
the same submission you made around how many weeks ago?
So, Your Lordship, it was ready, but this portion is required to be included as well. So, Your Lordship, it will come to 2 weeks, Your Lordship. By this time, I think I will get all the details. Otherwise, it will be not proper to file the reply, Your Lordship.
It's not proper for you to make these kind of submissions now also. It's a same, again, like rewinding and playing same song all the time.
This details should be collected from the Deputy Commissioner.
See. Twentieth 7. Five 7. How much more time is there, ma'am?
So at least 2 weeks, because we have to collect these documents.
What to do, Mr. Dev?
Well, I filed.
Become like, rewinding the same song over and over again. Same song is singing. Go to a new song at least. Today, Mr. Debnath has again renewed his prayer for filing of affidavit due to the unavailability of the latest information with regard to the recipients of the compensation. So, as these details are necessary, further 2 weeks' time is granted. So expected that the affidavit should be on board before the next date. Just after 2 weeks, yes.
8.
8 also same.
A different respondent. You are paying for respondent number?
That's number 6.
Then just record his name. All same parties.
9. Item number 9.
My lord, the intervention application before Supreme Court is not yet listed as the Constitution bench is going on.
What matter is this?
My lord, this regarding board issue. Board issue, we have challenged the MOU. Lord.
Then why is it here? It should be in the division bench with the other matters.
Because the SLP is pending the matter.
We know that. This is matter after 4 weeks to await any further development from the matter pending before the Honorable Supreme Court.
All right.
10.
For 3 weeks, my lord.
For what?
For hearing, my lord.
Why was the matter about? Ready?
I have no objection. He can take 3 weeks time. It's about resignment of contract, my lord.
You have no problem. 3 weeks. Okay. This is matter of 3 weeks for hearing. Okay. Records necessary? No.
My lord, might be required, my lord.
This is a matter for hearing after Klawai records. Let's mark here. In the meanwhile, the records of the from which court?
District Council Court.
From the District Council Court, be requisition. It's an appeal or you're filing 227?
227.
Item 11.
Mr. Sama was supposed to take the instruction. Is this matter, my lord, where
Yes,
title
yes.
suit
What
was not
happened?
transferred?
You want to transfer title suit to the appellate, to the other court?
Matter may come after some time, Lordship.
He was supposed to file an application to transfer the transfer petition, my lord.
He said to obtain after instructions whether to seek transfer or not, not to file application.
So he said that he will be filing an application.
He filed a miscase also. Oh, he filed a miscase. Wrong, different. Wrong. Among lawyers, where's Mr. P. Sama?
Courtroom number 4, Lordship. Please.
Okay, we'll wait for him. Let's call some time.
12.
Your Lordship, I pray for 2 weeks' time to file the affidavit.
It's a contempt matter. If you don't file affidavit, they have to come up here personally. How many times have you taken? Only once.
This is the second time, Lordship.
Okay, further 2 weeks time granted to the respondent's number
1 and 2.
to file the affidavit. Just thereafter also. If you don't file, then they'll have to appear and stand here for the whole day. Yes.
13.
Receive the copy.
I have received, Your Lordship, the affidavit.
We are just filing it, my lord. We have served him a copy, my lord.
You'll find rejoinder? No.
I was 38 first, Your Lordship.
Mr. S. the counsel for respondents 1 to 3 submits that the affidavit will be filed in the course of the day, just after 2 weeks for rejoinder, if any.
Right.
14.
Your Lordship, this is NIT matter.
And?
NIT matter.
NIT matter?
Yes.
National Institute of Technology or notice inviting tender?
There are two matters in the hearing list, my lord, today. In this matter, we have not filed affidavit.
You won't file? Make up your mind, you have to file, we'll grant time because after it's been recorded.
My lord, what I'm praying is all these matters can come up to 2 weeks, my lord.
Oh?
In the meantime, I'll file an affidavit.
It's here on the list today.
My lord. 34 and 35.
Who's appearing those matters?
Gautam, sir.
Mr.?
Yes, Gautam.
He's not here. 34 and 35. We can hear it otherwise. Are they ready, those matters?
Well, what I was praying is that all the matters can be heard together. See?
No, but with the counsel not here, we can't.
I'll inform them.
Yes, sir, Mr. Dr. Mozika, please be allowed further 2 weeks' time to file an affidavit in the incident matter. It's also submitted that similar matters are in the hearing list. In the hearing list for today at items number
34 and 35.
34 and 35. So, in these circumstances, what else, Mr.
Interim
Gautam?
relief maybe continue.
Yes, you
interim
want-
relief. Your Lordship, interim relief.
Dr. Mozika, he wants his matters together with this after 2 weeks. So he'll not file affidavit in the other matter, in this matter. 2 weeks already. This is a matter of 2 weeks. Yes.
Okay.
Interim orders shall continue. An interim order shall continue until further orders. Yes.
15.
I'll break for some more time to find the affidavit. Respondent 4 to 8.
Yes.
Break for some more time, to file the affidavit.
What's the matter about?
Regarding the appointment of a teacher in the Department of Commerce, Your Lordship.
Department of Commerce? Commerce College?
Yes, in Shillong College.
You are appearing for whom, Mr. S. Bhattacharjee? 1 to 3. You are 4 to 8.
I'm for respondent number 9, Your Lordship.
S. Jindal? 9.
Yes, Your Lordship.
Dr. Mozika, 10. Who are you? Who is this person?
Your Honor, I'm appearing for respondent number 11 on behalf of Ms. P. Agarwal.
Okay, yes. Ms. Ardata, you have already filed the affidavit?
Your Lordship requires some more time, Your Lordship.
Mr. Ardata for 4 to 8 and Bijurwa for number 9. Pray for not further 2 weeks time to file affidavit. Just the last one. Pray for and allow 2 weeks further time for affidavit.
16.
We have just filed our affidavit, my lord. You've received a copy, sir?
Yes. What about government?
May I please actually I pray for some more time. The affidavit is ready. I'm just waiting for vetting from the Advocate General Lordship.
It's fine opportunity. In the course of the day.
Lordship, in 1 week's time, Lordship. Last chance.
You pay cost then?
Lordship.
You file in course of the day, well and good. If not, 50,000, who said that? I thought you said it yourself.
Lordship, last 1 week's chance, last opportunity, Lordship.
What's the matter about?
It is 100 hectare, Your Lordship.
Mr. H. Kharwanlang, learned additional senior GA for response 1 to 4, submits that to 3 weeks time is granted as a final opportunity due to circumstances beyond his control. The affidavit has not yet been filed. He submits that the same is ready and will be filed within 2 days.
Lordship, 1 week's time.
Just for the asking is not there, Mr. Karwana. Or you are going to pay cost in 1 week?
Lordship.
You pay 5,000 cost?
Lordship,
No problem. You'll pay 5,000.
Lordship, I comply with your Lordship.
You want 2 weeks, 10,000.
In 2 days, I'll file Lordship.
Within 2 days, stop. Considering the prayer, the same is allowed. Stop. Mr. S. Day for respondent 7 submits that after we find the course of the day.
We have already filed it.
Oh, it's already submits that after the same has been filed. Stop. This is matter. You want to file rejoinders?
Sure.
This is a matter after
We'll receive.
1 week.
First
Yes.
we'll receive.
Yes, let's matter for 1 week for further orders. Yes.
I reply.
17.
Can I pay for a week's time? Paying for a week's time.
How many times?
I'll file it before the next day.
For number 2?
Number 4.
1 to number 4. Who is number 4 is what?
Number 4 is the school, madam.
So you private respondent?
Yes.
Mr. So who's P. Roy?
She's with me.
So for okay, so for please for the further 1 week's time to file affidavit. This thereafter.
18.
Please, Your Lordship. Your Lordship, we have received the rejoinder affidavit, Your Lordship. If necessary, we'll file a reply, Your Lordship.
Yes?
If necessary, we'll file a reply to the rejoinder.
No, what you file? You can't have rejoinder to rejoinder. Party submit the claims complete. This is matter for hearing after 2 weeks. Yes. No, you can't file rejoinder to rejoinder. You can make submissions.
19.
Ready? Only file.
We have filed our affidavit.
Number 4 is which party? Appearing for? Number 4 is one.
MPSC. MPSC.
Yes, Mr. Nath.
My lord, the affidavit which has been filed by the state, my lord, they have regularized my service, my lord.
Right.
Already regularized. On view of this.
I'm going to close it. Yes, Mr.
Paragraph 12 of the affidavit, my lord.
Where's the affidavit? Already recognized.
Right. That is it.
Affidavit has been filed today on behalf of the state respondents, wherein at Annexure 2 thereof.
Annexure 1 or 1, 2. Yes.
Annexure 2 thereof. Annexure 1 and 2 thereof. It is seen that the services of the writ petitioner have since been regularized. So in this view of the matter, nothing remains for consideration, and this writ petition stands closed. Yes.
And you are blessed.
20.
Not and disposed of.
May it please your Lordship.
Yes.
Lordship, in this matter, the petition was initially filed stating that the petitioner was terminated from service.
Please, MS Agarwal, come back to your own. You ask for rejoinder. Don't start on the merits if you not filed rejoinder as yet. You don't want to file, we'll close it. We'll close it.
I'm coming to that matter.
Then you come straight to the point. Don't beat on the bush.
Matter can be disposed of, my lord, on the basis of the affidavit in opposition.
What does it say?
My lord, if your Lordship kindly takes paragraph 8.
So first you won't file rejoinder.
Okay.
We'll note that, right?
Yes, my lord. I'm
Not
not
necessary.
ready.
Okay. Yes.
Yes, ma'am.
Yes.
My lord, if your Lordship kindly takes the paragraph 8 of the affidavit in opposition.
Yes.
That in reply to the contents made in paragraph 4 of the writ petition, the answering respondent submits that in the month of March 2020, due to COVID restrictions and as per government protocol, the department had to adhere to strict protocol for all employees under the department, which was published by government notification letter number so and so, dated 19 March 2020, and letter number so and so, dated Shillong, 19 April 2020, from 19 March to 4th January 2022. However, after restrictions have been reduced by notification letter number so and so, dated 4th January 2022, the answering respondent number 2 denies the allegation that the petitioner has been terminated from service. However, he was verbally informed that he has been terminated from service, and on that ground, the petitioner has submitted representations, 2 representations, my lord, on 22/3/2021 and 5/10/2021, stating that he has been terminated from service without following due process of law. No response was given to the said representations. Neither was it said that he has not been terminated from service. Now, my lord, by way of affidavit, the government has admitted that the petitioner has not been terminated from service. So, my lord, my humble prayer before this honorable court is that the respondents may be directed to allow the petitioner to perform his duties and pay his back wages, my lord, because all this while it was solely on the ground that he was verbally informed that he is terminated from service, that he has not been able to perform his job.
Yes.
In March 2021,
yes. Wait 1 second. Yes.
Please, Your Lordship. Your Lordship, actually there was no termination order, so the question of issuing a show cause is not required. Whatever it is, his willing, he has been absent on his own, Your Lordship.
No. See, now the allegation is that you're not allowed to work any further, correct? And that you've been informed, he's been terminated. Strange. Where is that? You're a casual worker or you're a regular worker?
Regular casual worker.
You're RCW?
Regular casual worker, madam.
Okay.
If your lordship may take page number 11 of the written petition. And the type copy is at page 12.
Number? You're at number 232.
I'm at season number 232.
Okay, 232. This is the as person. Right. So you have not been working since which month?
After the lockdown, my lord.
You've not been working.
Immediately as soon as the lockdown started, March 2020.
Terms of engagement, regular casual worker, you paid a monthly salary or you paid as and when you.
Monthly salary. I was posted at Fruit Garden Flower Section, Shillong, Malur.
Stop, take down. We'll dispose it off. If you take whatever step necessary, the petitioner who stated to be a regular casual worker with the respondent number 1 and 2 with the respondent stub is before 1 and 2 stated the respondents as before this court alleging that his services have been terminated without due process and that his termination was verbally informed to him, and in spite of representations filed, there has been no response. Stop. There's a response which has compelled him to approach this court by way of the instant writ application. Stop. Next para, MSP Agarwal, learned counsel for the petitioner, submits that the writ petitioner has been prevented from discharging his duties. Is that correct?
Yes, ma'am.
When he had presented himself before the concerned authority.
Lordship, if I can make one submission, Your Lordship.
Yes, please.
Actually, Your Lordship, the petitioner in this case, he was not regular in his duty. He didn't perform his duty.
That's up to you to take whatever action you can take subsequently. That I'm just recording her submissions. Okay, I'll record his submissions also. Thomna?
She submits that the petitioner has been prevented from discharging his duties when he presented himself before the Constitution.
And have been informed that he had been terminated. He, however, submits today that with the affidavit of position, by the affidavit of position filed by the respondents, it is seen that the respondents have denied that the petitioner had been terminated in any manner, and that the restriction on the duties was due to COVID protocol that had to be maintained at the relevant point of time. Stop. You're Mr.
Next.
She therefore, you're for your name?
J.N. Ranja.
Okay. She submits that in view of this averment made by the state respondents, the matter can be disposed of by directing the respondents to allow the writ petitioner to resume his duties and also to release his pending back wages, if any. Stop. Next paragraph. Mr. J. N. Rinja, the government advocate appearing for the respondents, has submitted that it is not a fact that the writ petition was terminated, and that it is due to his own absence. Did you prevented him from working or no?
There's no such thing, Your Lordship.
No, that's quoted out. Mr. J. N. General Counsel for the respondent submits that the writ petition was never terminated, as has been stated in the affidavit. Stop. Further, he submits that at no point of time has the writ petitioner ever been prevented from discharging his duties, but that the writ petitioner's own accord has been negligent and has absented himself without reason. So, he therefore submits that the writ petition, being without any merit, shall be dismissed with cost.
No, Your Lordship.
Okay, shall be dismissed. Up. Next paragraph. I've heard counsel of the parties and examined the materials and record. It is seen that the state respondents in the affidavit at para 8 and 9 have categorically stated that the writ petitioner was never terminated, and that it was never terminated. Stop. In this view, the matter, in this regard, therefore, the allegation that has been made by the writ petitioner doesn't seem to be correct. So, however, with regard to the other claims and whatever actions the respondents are to take, this court leaves it open for the respondents to take action in accordance with law on the claims of the writ petitioner as to back wages, considering his service record. I'll exchange it later on. As nothing remains for consideration, writ petition stands closed and disposed of. Yes. I'll change the last part with regard to what your representation for entitlements. Yes.
21.
Please, Lordship. Lordship, I'm supposed to file affidavit. I'm filing in the course of the day, Lordship.
What's the matter about?
Regarding that authorized boycott from the village, the social activities.
What's happening? Is still under boycott or
no, Lordship,
been
that
lifted?
is highly misleading. That's why we have filed affidavit. Lordship.
Have you filed it?
We'll be filing in the course of the day, Lordship. I've served copy to them.
For what about state?
You filed already, Your Lordship.
Yes, Mr. J. Shila for 5 submits that the affidavit be filed in the course of the day. List a matter after 2 weeks for rejoinder, if any.
Obliged.
22.
Respondents are yet to file the affidavit.
Your Lordship, will be filing the affidavit in the course of the day, Your Lordship.
Very good. MSS from House submits that the affidavit be filed. You of all the respondents?
Your Lordship.
Appearing for the respondents submits the affidavit filed in the course of the day. This is matter after 2 weeks for rejoinder, if any.
23.
May I please, Your Lordship? Objection, will you file objection?
We are not filing objection, Lordship. This writ petition is not maintainable. In fact, they have not come clean hands before this Honourable Court, Lordship.
Lordship, I have a small prayer, Lordship.
And there is no formal complaint.
Due to the urgent listing of the NRC matters in the Constitutional Bench, my senior Mr. K. N. Chaudhary will not be able to appear today, Lordship. A short date may be given, Lordship, for the final hearing.
We'll dispose it now only.
Yes, Your Lordship, because it's been pending for a long time.
Lordship, please, Lordship.
We don't need counsels also.
A short date,
The
Lordship.
Your Lordship,
Hard, Lordship.
we have been, in fact, Your Lordship has also been satisfied with our affidavit, Your
Any
Lordship.
short date, Lordship.
They are the ones who have committed atrocity against the actual owner of the property. Now they
Lordship on merits, Lordship.
Yes,
not
let the
be heard
police.
today, Lordship.
Yes, let the police.
Why should we entertain it?
And why should the
Lordship.
writ court go into a fact-finding thing whether
We'll
this?
not go there.
Yes.
Lordship, I'll humbly pray, Lordship. A short
It
date
will
may
not
be
make
given
any
for.
difference, Lordship.
A short date may be fixed for hearing, Lordship. Final hearing, Lordship.
They have not filed any rejoinder against our affidavit. They are expecting us to give an objection with.
No, doesn't matter.
Let us dispose.
It's a police matter. What
Yes,
is the
Your
court to do?
Lordship.
Lordship, we are here. No, Lordship, we are here because of.
Your Lordship,
We'll just give him one more chance.
Since the last occasion,
In the
Your
interest of
Lordship
justice, the
was.
matter stands adjourned to after 4 weeks.
Oblige, Your Lordship.
As prayed by the then counsel petitioner. Yes.
May I please, Your Lordship? Your Lordship, the affidavit has been filed by the District Council and the respondent number 5 is yet to enter appearance, Your Lordship. And Your Lordship, in the meantime, I pray that the interim prayer may be considered, Your Lordship.
What's the
And
matter
if Your
about?
Lordship, this is with regard to the appointment of Gambura, Your Lordship. And if Your Lordship may come to the affidavit filed by the District Council
Yes.
in page 14, Your Lordship.
Page 14.
1-4.
But what does it say?
If I may read, Your Lordship.
Yes.
A public meeting was held on the 29 May 2022 at 3 p.m. in the Jugirjhar Government LP School premises to discuss the selection of new Gambura of village Jugirjhar on the event of the demise of the existing Gambura of the village, late Jahanur Mullah. Your Lordship, the reason given for the proceeding was on the demise of the existing Gambura. But Your Lordship, Jahanur Mullah was no longer a Gambura at that relevant point of time, Your Lordship. His appointment was already cancelled by the District Council, Your Lordship, and in his place, the petitioner was appointed, White order dated 16 March 2015. And the proceeding was conducted, Your Lordship, by mispresenting that fact, Your Lordship.
No. Who held this meeting?
One Shri...
No, it is the villagers.
Certified person.
Kiran Barman, Your Lordship.
They all supported Mokibul Mullah. Where's Mokibul Mullah? You are appearing?
No.
One
He has
issue.
not entered appearance still. The meeting was totally one-sided, Your Lordship.
What you elected the son of the old Gambura? Is hereditary? Is Gambura there?
Sorry, my lord.
Is it by dynasty?
No, it's not by dynasty, but my lord may kindly see the facts. My lord may kindly see the writ petition.
He already died that time when this meeting was held.
Yes,
Yes.
he died. My lord may kindly see the.
But he was no longer the Gambura, Your Lordship.
My lord may kindly see the writ petition copy.
No, let's see, because they'll be the authority. We won't need the other respondents on the facts, yes.
My lord may kindly come Annexure 1.
Yes.
Annexure 1, 16 March 2015.
Sorry. Lecture 1.
Annexure 1. Page 13, my lord.
Yes.
On the basis of the public complaint and recommendation, the Executive Committee is pleased to cancel the appointment of Jahanur Mullah, Gambura of so-and-so, and it should have been in his place, Khan Bahadur Sheikh
Yes.
is appointed as new Gambura for the following village, my lord.
Yes.
Now this order was challenged before this honorable court.
Yes.
And this honorable court, while order dated 1/4/2015 in page 14, passed an interim order.
Yes.
I don't make kindly see the second last paragraph. On considering the submission of the learned counsel for the petitioner and on perusal of the writ petition, it appears that there is a prima facie material for passing ad interim order. As an ad interim order, it is provided that the operation of the impending order so and so shall remain suspended till the next returnable date. It was in stay, my lord, status quo order, till the matter was dismissed, my lord, as infructuous. That is on page 16.
Yeah, but that when he died that time.
Yes, my lord may kindly see the fact that his appointment was in 2015.
Now he's taking claim from the back door again.
From the back door again. And my lord may kindly see his appointment on the recommendation, on the basis of the public complaint and recommendation. There was a recommendation given by the MDCs. So the executive committee appointed him.
Jahanur Mullah died, and that's why he had a fresh election then.
We had a fresh election.
Yes.
And if the petitioner is so agree with the order, let him face the election. We are ready to conduct the election.
But your lordship, the election was conducted one-sided. I was not even given a notice also, your lordship, as to the proceedings.
My lord, it is a villagers. It is not.
No, what happened to this? Why didn't contest it then?
He was present, my lord.
No, your lordship.
He was present.
First order was passed in 1st of April 2015. You didn't contest it that time.
Pardon, your lordship?
You didn't contest it that time, 1/4/2015.
2000.
See,
I was appointed, your lordship.
You were appointed that time by the order dated, correct, 16 March 2015. Okay. Then whoever came to court, then your appointment was stayed. You didn't contest the matter at all. During that time before this court, you didn't contest it.
I was contested, your lordship.
Then how come it became till it got disposed of just last year in 22?
I'm not aware of that, your lordship.
7 years you just slept. You don't want to be Gaubura. So after this old Gaubura died, you said, okay, fine, my time.
Now let me go back and check.
No, we'll just pose it off. I don't think he made out any case.
My lord, may kindly see the photograph. The villagers has given the photograph. He was present, my lord.
Now the thing is that now your order is that in person order Honorable High Court so and so, Executive is pleased to appoint Sri Mokubal Mullah. Now that also it's just that you appointed him yourself unilaterally.
No, my lord. There was a proposal given. There was a proposal given by the villagers. My lord, see the proceeding, my lord.
Now this public meeting was held on 29 May, and upon order of the private respondent was on
15 June.
Okay.
15 June 2023, your lordship. But your lordship, my appointment order was not even cancelled, your lordship. Was not stayed aside.
So after 5 years, my lord,
was not set aside by this court also.
That order remains.
7 years. Even if a person disappears for 7 years, considered dead. An interim order after 7 years, forget about it.
That will be more after perusal of the reports on the
If he is so agreed, my lord, we are ready to conduct an election. Let him face the election. If he enjoy the majority of the villages, then
he'll face election again. Because since the respondent final not appeared, I think he deserves also that he tests, that he gets tested by election also. He can't just ride piggyback on the district council. We'll pass orders then.
Fine. And only thing is this, in the meeting, my lord, I'm pointing out, he was present, my lord. We have made a statement also, and his photograph is there, my lord.
But that photograph was not enclosed also, your
You were not enclosed, but the photograph is there that he was present in that meeting.
How will the court know who is the person?
Exactly.
My lord, at least my friend will know who is her client. Probably she will know.
But this photograph was
She will not know, my lord.
lordship.
And it's taken from the back. How do you know? It's not from the front also.
Lord, my lord, a photograph in the village, my lord, they face to.
Yeah, they're facing the other side. How will you see the face, Mr.?
Well, then may not consider, but
how will you? That's why you didn't annex the photograph. How will you?
My lord may not consider.
How do you see his presence?
But the fact is this, my lord, he was present.
But whether the date is reflected in the photographs also, your lordship.
These are very hyper technical questions.
That's correct. Might be some other gathering.
That's what it is.
My lord, assumption, presumption can be
this
anything.
Open court. Better you have any doubts, you can sound it. Yes. Yes, the brief facts necessary for this case are that the petitioner seeks to base his claim on an order dated 16 March 2015, whereby he was appointed as Gaumbura of Jugurghar, Jugurghar area, as there were complaints against the then Gaumbura one Sri Jahanur Mullah. Stop. The said appointment order, however, came to be stayed by an order of this court dated 1/4/2015, and on the death of the petitioner, therein, bracket Jahanur Mullah, the matter was closed by this court by order dated 3/6/2022. It is in view of this development that the writ petitioner has come by way of this application to seek renewal of his appointment to be the Gaumbura of the said area in question, of said Jugurghar area. In the writ petition, the writ petitioner is also agreed with an order dated 15 June 2023. 2023.
Yes, sir.
Whereby respondent number 5 has been appointed as Gaumbura. It has therefore been contended that with the death of the earlier Gaumbura, the appointment order 2015 stands revived. That's your submission, correct?
Yes.
And that the writ petitioner should be the rightful Gaumbura of Jugurghar area. Stop. MSAP Khaswano paragraph, counsel for the petitioner has submitted that the appointment of the respondent number 5 is illegal inasmuch as the prior appointment of the writ petitioner was not taken into consideration when the said imperial order was issued. Stop. He further submits that the writ petitioner, having acquired a valuable vested right to the post, the deprivation of the same has resulted in grave injustice being caused. Stop. He therefore prays that the imperial order be set aside and quashed, and the order be revived, the 2015 order be revived, and that the earlier order dated, what order dated when?
16 March 2015.
Be revived, and the writ petitioner be allowed to assume the office of Gaubura of Jugalghar area. Stop. Next paragraph. Mr. S.D. Learned Counsel appearing for the respondents 1 to 4 has referred to the affidavit filed and submits that it is not a fact that the respondent 5 was elected without due process. Stop. The Learned Counsel has drawn the attention of this court to Annexure 1 of the affidavit, which he submits are the minutes of a public meeting held on 29 May 2022 with regard to the selection or election of the new Gaubura for the said area, namely the respondent number 5. He further submits that the earlier order appointing the writ petitioner after same had been suspended by the court and not re-agitated has since lost its force, and the public of Jugalghar area, having elected the respondent number 5, in a public meeting, any right that the writ petitioner possess has since been extinguished. He therefore submits that there being no submits that there being no merit therefore in the writ petition, the same does not deserve any further consideration. Stop. Next para. Having heard the counsel of the parties, firstly it is noted that it is a fact that the writ petitioner had been appointed as the Gaubura of Jugalghar area on 16/3/2015, which however was suspended by order of this court. Stop. It is also noted that no materials have been brought on record to show as to whether the writ petitioner had actively contested the writ petition or not. And the only other order annexed is of the closure of the same. Stop. In the considered opinion, in the considered view of this court, the writ petitioner, having slept over his rights for over 7 years, cannot take recourse to and seek to take the aid of the earlier appointment order to renew his claim for the post of Gaubura. However, it is also noticed that you're not there in the meeting, you sure?
No, Your Lordship.
How it is also noted that in the minutes of the public meeting, his presence cannot be discerned as to whether he had offered himself as a candidate for the said office. So, this fact is, however, also is disputed by counsel for the respondent. Who has submitted that the writ petitioner was very much present. So, this court, sitting in writ jurisdiction, is not in a position to ascertain as to whether the writ petitioner was present or whether he had taken part in the proceedings which were held as far back as on. This was held on 29 May 2022, and the appointment order is 23.
Yes, madam.
I don't know.
This proceeding with jurisdiction is not in a position to ascertain as to whether the petitioner was present or whether he has taken part in the proceeding, which was
As far back as on 29 May 2022. Coupled with this is the fact that the appointment order is of recent. One order is, when the date?
15 June 2023.
Is dated 15 June 2023, which is after a period of over a year from the said meeting. Stop. The facts as they pertain having raised questions which need some consideration. Stop. Next paragraph, the facts need consideration. It is therefore necessary for the ends of justice that the respondents have a relook at the matter concerning the election and office of the Gaonpura or Jugirghar area. And if on a review of the matter it is deemed necessary, they shall conduct a fresh selection process by giving all concerned parties adequate opportunity to take part in. With the above elections, matters dispose of. You can have a relook. Let's see.
We'll do that.
25.
Instead of directing for such elections. Yes.
May I please, Your Lordship?
Yes, you.
That revenue officer issued an order on 2nd August 23, my lord, with a copy to me in respect of expert inquiry for appointment of the new Gambura, whereas they have not served me any copy, and till that no inquiry was conducted by these two.
You got the letter dated 2nd August?
Yes.
See, this is address. You are, what's your name? Abdul Mateen.
Abdul Mateen.
Yes. Subject, this is to the Aston Moza
Moza, assistant Moza number, so and so.
Yeah.
Moza
Spot
6.
inquiry hereby directed to proceed a spot conduct spot inquiry in respect of new Gobra appointment of Maula Kandi area, place of late Abu Bakar, so and so, who expired also, and the and demanding for action, submit the report detail assigned. So,
where is there is no inquiry? They have not served any notice to me till
they have
date
not come as yet. They are in the process.
My lord, it is in the process. On the basis of his letter, we have initiated something. Now, whether that application can be considered as not disposed of. Now, if he is aggrieved with non-conducting
of you didn't read here last time.
Here, my lord. Here, my lord.
You take part.
No, yes, I will take part only.
Yes.
I won election only, my lord.
Yes.
Nothing else. So direction may be issued for held election.
First of all, inquiry first whether the Maula Kandi people they won election or not.
They won election or not?
Yes, but where is the inquiry report, my lord?
It's not been done as yet.
It's not been done. We are saying that it's not been done.
But here they have mentioned within 10 days. Now more than 1 month.
My lord, it is on the process. Now probably they have communicated to the secretary that we need
They
some
will
more
give the
time.
inquiry. Process means.
So in
process
the meanwhile,
means what, Mr. Hazarika?
Yes,
process doesn't mean that you go for inquiry one day and it's over. Yes. Suppose a court appoints an advocate commissioner to go and conduct some inquiry.
Yes.
Correct?
Yes,
so Mr. Hazarika, one fine morning, he leaves his house and goes for inquiry.
In
doesn't mean inquiry is over. You make a report, it has to be given to the court, and the court consider it, then we'll pass orders on your report. Correct?
Yes.
Then?
No. In that case, my lord.
We'll pass orders.
No.
Order.
In that case, my lord, only my pray that writ petition may pending. Meanwhile, let them.
No pending. Yes, the writ petitioner being aggrieved with. Agree with what?
For non-election.
Non-disposal of his representation.
No. And the election of the, we are pray for election of the new Gambura, my lord.
Being aggrieved with the non-disposal of his representation for initiating a process to elect the new Gobora of Malakandi.
Yes, can I just point out, my lord? The application was filed on 7/7/2023.
Yes.
And then he came in the month of July before this honorable court. We have acted promptly on his representation.
It's all right. Yes, no, we'll record that.
Yes.
No? I'll file instant petition. Stop. On the last date, that is on next paragraph. On the last date, that is on 5/9/2023, the counsel, Mr. S.D. counsel for the district count for the respondents number.
Respondent number 1, 2, 4.
1, 2, and 4 has produced a letter dated
2nd August.
2/8/2023, whereby it has been indicated that orders have been issued for conducting a spot inquiry in respect of appointment of a new Gobara for Maula Kandi area in place of the earlier Gobara who had expired on 26/6/2023. Stop. It has been submitted by the council also that the representation of the writ petitioner was received on 7/7/2023, and the respondents are actively considering the matter, and there is and depending on the inquiry and the report generated therefrom, necessary orders will be passed on. Like Ms. Azarika, in view of the development, has no further submissions to make, only that the same be completed expeditiously.
Yes, my lord. And the inquiry, when they have conducted, my lord, it must inform to us, my lord.
Yes, and that they'll be given adequate opportunity to represent themselves in case of any further inquiry. Stop. In view of the submissions and in view of the letter dated 2nd August 2023, new submissions made by the General Councils for the parties, this matter
within some specific period, my lord.
Yes.
Within a 1 month, my lord.
Yes. It is expected that the entire exercise
One
should be
week.
completed within
3 months.
within a period of 3 months. Yes.
26.
You file representation one after the other.
Let him come before.
Yes.
No, sir. Because my lord, the other was problem for birth certificate.
Yes.
That is the problem.
Yes.
My lord, in this matter, they have, on the last occasion, if my lord may kindly see 31st/8/2023's order.
Yes, what other instructions have you got?
Your Lordship, the investigation is going on, Your Lordship.
You said charge sheet been filed?
Not yet, Your Lordship. But,
Then?
notice under section 41A has already been issued, Your Lordship, to report the case, Your Lordship.
So then we'll close it.
My lord, because they have informed us now.
Ms. M.S. Ailangwa submits that the investigation is still underway, is in progress, and that notice under section 41A has also been issued to the concerned people. Stop. In this view, the matter Ms. S.D. says that the matter be closed. Yes, apparently the matter still closed. Close this post, leaving the authorities to act in accordance with law. Yes.
27.
Yes, possibly from the thing.
Madam Smith, I have received the instruction. The letter was issued by the Council revoking the impugned order. On the prayer, my Lordship may close my petition with the observation that the election committee, who is statutorily bound to take appropriate steps for conducting elections.
Yes,
I am entering a parent behalf of the respondent number 3.
Election committee. So when will you hold elections?
Yes, thank you.
In fact, you want to place on record.
There's no grievance against you. There's no relief claim against you,
Yes,
Mr. Suna. Then what do you want?
What we want is just to place how we start the election and how it comes to it.
No, we don't want that. We don't want illustration of that. Mr. S.M. Suna, then counsel has added appearance behalf of respondent number 3 today. Stop. Next paragraph. Mr. H.L. Sagreso submits that in view of the
letter dated 8 September.
In view of the letter dated 8 September 2023.
My lord, if I be inclined to dispose of this petition, my only prayer is that the election may be, we will conduct the election within a month's time.
That's up to you. We've not seen this. That's up to you.
One more submission, my lord, regarding that application for those intending elector should not be.
There are some voters who have not been included in the list.
Because times the policy.
See, the only thing is that if you have inclusion of new voters in the list, they have to be given time to object. That is all part of election procedure. If you're introducing new voters, if the voters has already been finalized, normally you don't include. If a date election has been fixed and the voters list has been finalized, there's no question of inclusion of new voters. That's the only thing. Yes.
You go by the existing LA.
Whatever, that is entirely at your discretion. That's what Mr. Kinta said last time. That the ball is in your court.
We don't interfere.
Yes, Tom. Yes, the grievance of the petition has been addressed. He, however, prays that the election respondent number 3 committee be directed to conclude the election process as early as possible by fixing a fresh date of election. Niche Vijayanta for respondent 2 has no submissions to make. Only submits that the entire matter rests with the election respondent number 3 in the manner and conduct of the elections for Sardar Raj Shabang. In view of the submissions made by the councils of parties and in view of the recall of the impugned order dated 28 August 2023, so nothing suffices for consideration in the incident petition. However, it is expected that respondent 3 shall conclude the whole process most expeditiously in accordance with law and procedure. Yes.
Yes.
I look.
Second call, item 11.
Lordship, as per this order dated 4/9/2023, Lordship, I got the instruction because that earlier This as per the court order, High Court order dated 089/2022, there was a direction to transfer the case of
only Mr. Appeal is transferred, not the case.
Yes, only this case. So I got the instruction. So he said that even the main case of title suit 8 of 2013 2013 also can be transferred to the same court.
Where is,
I have filed a small application also.
1 second.
In that effect, it is there in that.
You won't lose ladder of appeal. You don't mind losing a ladder of appeal by transferring title suit also. You don't mind losing one ladder of appeal. You answer my way ladder of appeal. Now you're bids for presiding officer, correct? Now the appeal is being taken up by the additional judge. Now you want title suit to be taken up by additional judge also. That means you'll be using a ladder of appeal.
Yes, Lordship.
Correct.
Lordship.
You're prepared to lose that.
No.
You're prepared to forego that appeal. You'll come straight to High Court after that.
Lordship, but instruction is
what do you want?
That the petitioner want that title suit also can be, that it also can be transferred to that miscase, to appeal miscase to.
Where's the miscase?
Since I have filed the law.
Miscase 11 today. Yeah, new one. 15.
In the record.
What was the day?
Your Lordship, he is like on other court. If the matter may come up after 1 week.
After 1 week? He'll be in leg for 1 week in the other court. 1 second. We'll tape tomorrow.
Lordship.
They don't come. This is matter tomorrow. Tomorrow, day after, same thing.
Sir, 1 week, Lordship.
1 week? Why? You're going somewhere?
No.
This is day after tomorrow then.
Lordship.
Yes.
First place, Lordship.
On the prayer of the counsel for the respondent is the day after tomorrow.
Hearing.
First place, Lordship.
Item 30.
My lord, if this is taken at the end of the body, it's kindly taken at the end of the body.
Wait, my lord, this is a pattern matter, your lordships.
Why you?
My lord, I have another matter before.
This court takes precedence, I think. Only Chief Justice Court go before this court.
Called out, and then he say anticipating another case he will reach in some other court, my lord. That should not be encouragement. Sorry.
Who's there with you in this case? Who's there with you in the case? You're alone? Thungwa. Yes. What about this other matter, this number 31? What's the matter about?
That is regarding Lordship conferment of benefit by mistake, Your Lordship.
Okay.
Which is not entitled to aspect.
Yes, Pap. Where were we?
Just to remind, my lord.
Yes.
Just for refreshment. Lord, the petitioner are the teachers.
One second, let's come back in 2 minutes.
My lord.
Let me take a. It will take some time.
Yes.
You are on your arguments were that if the PA is totally state funded,
Yes, sir.
then it is a state discretion whether they give those additional, the
Increment.
increments. Yes. Correct. And since if it is part was borne by the UGC, then they are entitled to increments.
Yes, madam.
That's the basis of the argument, correct?
That is the basis.
Okay. Continue. So I just want to see whether I understand it or not. I mean, in correct perspective.
The petitioners, on the other hand, my lord, their case is that
Once you adopt it,
yes,
you're bound.
Yes.
Yes.
Now the petitioners are relying, my lord, on the letter issued by the government. Yesterday I was going through it again, my lord, carefully. But petitioners are primarily relying on the letter which is issued by the government of Meghalaya, my lord. That is at Annexure 2. Annexure 2, page 38 of the writ petition, my lord. And typed copy is at
Annexure 2.
Annexure 2. Typed copy is at page 42. Annexure 2, page 38. And the typed copy is at page 42.
Page 44.
42 of the writ petition.
Okay.
So, my lord, I was going through the language of this letter, my lord. Now, whether this letter is a final letter, my lord, or there is another decision which is to come, my lord. Lord, if I'll read the typed copy, my lord.
Yes, read it. You have all the time in the world.
The undersigned is directed to say that the state government has ordered the adoption and implementation of UGC norms as per the Government of India letter dated 31/12/2008. My lord, the language says has ordered the adoption and implementation. It does not say it has adopted and implemented.
Has ordered adoption and implementation.
My lord.
How can you have any doubt about that?
My lord, kindly come to the last paragraph, my lord.
You will note that.
Paragraph before that, my lord. If I take my lord to para 10, my lord.
Of this letter.
Para 10, yes, my lord, of this letter, which is at page 47. So para 10, the last two lines, my lord. In case of the lecturers of deficit colleges, the grants will be released to all the governing bodies concerned according to the normal procedure against the sanction post, subject to fulfillment of the condition laid down from time to time.
Yes.
In case of lecturers in government colleges, they should obtain pay slips from the Accountant General Office and draw the same according to the authority issued by the Accountant General, A.E. Meghalaya, Shillong. Lecturers are directed to remain in the colleges during class hours to guide the students for counseling, corrections and assignments, co-curricular activities and other related matters for the welfare of students. A compliance report should be submitted by the college concerned along with the utilization certificate. Lord, this is for the grants which is being given by the state to the deficit colleges. Any difficulty, para 11, my lord, any difficulty which may arise in the implementation of the provisions relating to the revision of pay structures as indicated in this order may be brought to the notice of the state governments for decision. So I'm relying on this paragraph, my lord.
Now one thing, Mr. Bhattacharya, see, what do you have to say about para? You come para 6, you come to para 6, sub para 3. And para 8, sub para 1.
Fixation of pay. It speaks of, my lord, fixation of pay on promotion, placement, on account of career,
scheme CS benefits on or after 1st January 2006. Career advancement. Now, if we go to the event, assuming that it is applicable, my lord, even if we go to the UCG regulation, my lord, career advancement scheme does not speak of increment, my lord.
Okay, no, you can do your submissions. What you want to say with regard to para 10? You said it does not confer anything on them.
Yes, my lord.
That's what you're trying to say.
Yes, my lord. And para 11 also, my lord, says that there is the complete, that means it says, my lord, the complete decision is yet to be taken, my lord. Any difficulty, otherwise why would they issue this direction, my lord? Any difficulty which may arise in the implementation of the provisions relating to the revision of pay.
Difficulty means there's other things. See, we have to reconcile yourself. I mean, like, if you want to, this letter, the purport of the letter, see, it says revision of UGC scale of pay so and so and so. The undersigned directed to say that the state government has ordered the adoption and implementation of UGC norms as per Government India letter so and so. That's the thing. See, and then you read the same para, come to 5, 6, and the UGC scale of pay and DA central government rates shall be applicable to all eligible teachers, government colleges in Meghalaya on a submission of option, and the age beneficiation shall be applicable to state so and so. How do you get over this letter?
My lord, that is there, but this is to my understanding, my lord, because otherwise it should have said, my lord, the state government hereby adopts, my lord. That should.
What do you say in affidavit with regard to this letter?
We filed an additional affidavit, my lord. But in our additional affidavit, we have stated, my lord, that as far as the increment is concerned, my lord, there was no policy decision taken by the government.
No, specifically with this letter?
Letter, my lord, we have quoted this letter. We have quoted this letter.
1 second.
In the additional affidavit, my lord. But of course, we did not make any specific averment. But this, my lord, when I went through it, carefully went through it, my lord, it came to my mind that this could be another possibility, my lord.
Another possible area of argument.
My lord. My lord, will kindly see my affidavit. My lord, this is that scheme of revision of pay, which is additional affidavit, page 3, my lord.
1 second. Page 3 of your additional affidavit. What do you say?
I'm allowed to read.
Yes.
On the recommendation of University Grants Commission, the revision of pay for university and college teachers is notified by the Ministry of Education, formerly known as the Ministry of Human Resource Development, from time to time. This exercise is usually carried out every 10 years or so. It may be mentioned that the said exercise is undertaken by the MOE/MHRD subsequent to the acceptance of the revised pay scales of the central government employees as recommended by the Central Pay Commission. So this follows thereafter. In the instant case, the petitioners, so we have stated that it is the petitioners who placed reliance, my lord. On letter, MHRD letter dated 31/12/2008 regarding the scheme of revision of pay of teachers and equivalent cadres in universities and the colleges following the revisions of pay scales of central government employees on the recommendation of the 6th Pay Commission. The said scheme incorporates revised pay scales of incumbent teachers placed at various stages. So, my lord, that they are getting that benefit, my lord, of their career, and pay fixation formula for the existing teachers as well as the teachers who are going to be recruited subsequent to the implementation of scheme. So here we refer to the letter, the government of Meghalaya.
A bit confusing. Now, why do you say that in the affidavit that is issued prior to the 2010?
Yes, my lord, because the UGC regulation, this letter was issued, my lord, this letter My lord, the letter which we are referring to, my lord, this letter
It's 28
23rd March
2010.
2010. My lord, this gives assent to the, or this letter speaks of, my lord, the MHRD letter dated 31/12/2008. But whereas, my lord, the UGC regulation came thereafter, my lord, after the issuance of this letter.
Okay.
UGC regulation did
That's
not
one
come
point.
before that, my lord.
Yes.
So our, my lord, limb of argument or our contention in this affidavit was that the government could not have adopted the UGC regulation which came thereafter, at least by this letter, my lord.
Yes.
So that was one of our contention, that the UGC regulation came after the issuance of this letter, my lord, at a later date. And whereas this is issued in the earlier date, and it speaks of the MHRD letter which is dated, my lord, August of 2020.
So you see, it's only confined to that MHRD letter.
My lord.
But it speaks of adoption of the UGC scales.
It speaks of implementation of UGC norms, my lord. The language of the letter is, my lord, if I'm allowed to read, the undersigned is directed to say that the state government has ordered the adoption and the implementation of UGC norms as per Government of India letter so and so, my lord. It speaks of UGC norms, but here it does not speak of UGC regulation. It cannot be, because that came subsequently, my lord.
No, what is good saying that you see the whole paragraph shall be, they say shall be the UGC scale of P and D income shall be applicable to all eligible teachers.
My lord,
the broader arguments that once you accept this UGC scale, the whole package means that it comes in increments also. Whether you can in one hand give them UGC scale, in the other hand deny them like what comes with the package. That is the case, correct? The package, okay, you have like this a basket of, you're buying this whole basket, you see,
but
okay, fine, you're entitled to this basket of goods, right? There's apples, oranges, and maybe lemons.
My lord, the package,
so when you give that package, so no, we can't give the lemons because
my lord, the package,
yes,
my lord, the package comes with the fact
conditions,
my lord.
The lemons we can take away.
That package, my lord, that package we are we will have to follow in toto, my lord, when it comes to receiving grant from the center or from the UGC, my lord. Now, when the question of grant, that means 80% is being borne by the central finance, my lord, and 20% by the state. Now, what do we? Now, when it comes to a case where, my lord, the whole finance is by the state or borne by the state, my lord, whether it can be mandatory that yes, you have to give the increment as well, because as far as the pay revision from time to time they are getting, there is no denial, my lord.
No, that's what the
when it comes to the increment,
I see the basket, three things. Then
because
you say that if UGC gives 80% and 20%, then they entitled to the entire basket. Lemons, oranges, and apples.
No, my lord, because the discretion is there, my lord. Some Supreme Court judgments, of course, Honorable Supreme Court judgments have said that the state has the discretion. Now, my lord, only problem here is that as far as the issue of increment, my lord, I looked it up. I have hardly come across any judgments primarily on the increment, my lord. The judgments which I have come across is mostly on the age of superannuation, my lord, where there is a difference. And my lord, the issue, and another issue was the appointment of the, another issue which my learned senior relied upon, my lord, that's issue of the appointment of the Vice Chancellor, my lord. Now, this is an area, my lord, where I have not come across Honorable Supreme Court judgments with regard to the increment, my lord, whether there can be any differentiation, my lord. But my respectful submission, my lord, because the whole thing is being borne by the state. Secondly, my lord, there is not a single letter issued by the state after the coming to existence of the UGC regulation that, my lord, that the state has adopted the UGC regulation, my lord. No doubt. Okay, we assume that it is accepted that even if it is accepted that state has granted his acceptance on the ministry MHRD letter dated 31st March 2008, my lord. But there is subsequently there is no letter issued from the state government stating that.
I don't know how.
And my lord, even if we go to the UGC regulations, my lord.
You had referred to the scheme. You had referred earlier on. Or Mr. Sen.
Mr. Sen.
So that's appendix in the scheme.
Yes. Now, even UGC regulations, my lord. If I take my lord to the UGC regulation.
Yes.
My lord,
because see, what are increments? You go back to the basics. What are increments usually? What are increments in the service career? What is an increment?
My lord, increments is.
Increment is what?
From of course.
Increments like
certain amount of increase, my lord.
Increments what? Increments means it's like it's encouraging kind of payments that are made for a person's service career.
My lord.
And suppose like even suppose the dispute proceedings against someone. Correct. Now, a punishment minor penalty can be also you're not allowed increments or 2 increments or 3 increments are withheld. That amounts to punishment also. Correct. So, what are increments basically? So, increments, like common understanding is that if you have paid a certain pay scale, you're given other benefits and all, as you proceed in your career,
yes,
then you're given additional increments. You understand? It's like that. So then because they have that you cross the efficiency bar, you get increment, so on and so forth. Right? So the increments come along with the entire, like what we're calling the entire package now. So how can you divorce increments? If you're already adopting the pay scale which is admissible as given by the UGC, if you're already adopting that and paying your lecturers and professors that, not lecturers, some professors that now, whether you can withhold that other part. That's the only question here.
My lord, our respectful contention is that, my lord, that there is, at least as far as the increment is concerned, my lord, here the petitioners are claiming.
You have the discretion. You mean since you're paying the entire salary, you have the discretion to not afford that added bonus for them.
Because it is, we have
it's not a bonus, but
we have stated in our additional affidavit, my lord, that the state cannot, my lord, bear the burden of additional increments or promotional increments, my lord. That is the contention of the state, my lord. Now, my lord, if I take my lord to the UGC regulations, this page 7849, my lord, the third page, first, second, third page. 7849 is the page numbering, my lord. But this is with the regulation, it is the third page, my lord.
Yes.
UGC regulations on minimum qualification for appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in the higher education 2010.
Yes.
These regulations are issued for minimum. This is the basic criteria behind the issuance of this regulation. These regulations are issued for minimum qualifications for appointment and other service conditions of university and college teachers, librarians, directors of physical education and sports for maintenance of standards in the education and revision of pay scales. Now, my lord, here it says 2 pay scales, pay fixation formula, and age of superannuation, etc. So, my lord, what has happened is that several decisions are there as far as this superannuation is concerned, my lord, before the Honorable Supreme Court. These issues were raised, my lord. 2.1. The revised scale of pay and other service conditions, including age of superannuation in central universities and other institutions maintained and or funded by the University Grants Commission. So, my lord will kindly see, most important, institutions maintained and or funded.
Okay.
So that creates the binding aspect, my lord, not otherwise. Or funded by the University Grants Commission shall be strictly. My lord, it does not speak of universities where it is not funded. where it is not funding or where it is not maintaining, my lord, shall be strictly in accordance with the decision of the central government, Ministry of Human Resource Development, as contained in Appendix 1. Now again, I take, my lord, to Appendix 1, my lord. Appendix 1 is at, my lord, page 7922, my lord.
Yes.
My lord, it contains several aspects.
You got that letter, MHRD letter, 31st 12, 2008.
My lord, here this letter contains, my lord, it's a lengthy letter. So, my lord, it speaks of increments, but however, my lord, I will take, my lord, to G, my lord, which is at page 7934, my lord. G, which speaks of pension, my lord. So this is also, yes, my lord, this same letter, appendix starts from 7922. So I am taking, my lord, to page 7934, my lord.
Yes.
My lord, it speaks of pension. Now it is that same appendix which also speaks of pension, my lord. Now my lord will kindly see, the petitioners herein, being the deficit school teachers, are not getting any pension. They are not entitled to any pension. But whereas this is part of the appendix.
Deficit school teachers?
Sorry, my lord. Apologies, my lord. Deficit college teachers, my lord. My lord, they are not entitled to any pension. They are not getting any pension. It's a policy decision of the government. But however, my lord will kindly see, this pension forms a part of the appendix. So if it is to be believed that, my lord, that this has to be followed in toto.
No, but then there'll be members of NPS, whatever they have that scheme where they contribute to the pension. No, NPS, sorry, they have another scheme.
My lord, of course, old pension scheme and NPS, my lord.
Yes.
But here, my lord, those will not be applicable. They being the deficit school teachers, college teachers, my lord. My apologies.
We are demoting them to the status of school teachers.
So my lord will kindly see, because if everything was to be followed, now that is one aspect. Another aspect, my lord, is as far as the age of superannuation is concerned. On that, of course, several honorable Supreme Court judgments are there, my lord, where it is stating that the state has the discretion to.
Or what age superannuate them?
Yes, my lord.
Okay. So you say pension makes it like, although it is given there, distinction has been made.
Yes.
They're not entitled to pension. Okay.
My lord,
I'll note down, even though you. Yes.
Now, my lord, I take, my lord, to the next page, my lord, applicability of scheme.
Yes.
Which is at P, my lord. So if I am allowed to read, my lord.
Please.
This scheme shall be applicable to teachers and other equivalent cadres of library and physical education in all the central universities and colleges thereunder, and the institutions deemed to be universities whose maintenance expenditure is made by the UGC. My lord will kindly see. The implementation of the revised scale should be subject to the acceptance of all the conditions mentioned in this letter, as well as the regulations to be framed by the UGC in this behalf. Universities implementing the scheme shall be advised by the UGC to amend their relevant statutes and ordinances in line with the UGC regulations within 3 months from the date of issue of this letter. This scheme does not, no, this is not important, my lord. Then, my lord, I take, my lord, to subpara 5, my lord. This is where the discretion is given to the states, my lord. So it is not binding. This is the next page. My lord.
Yes, I've seen it.
This scheme may be extended to universities, colleges, and other higher educational institutions coming under the purview of state legislatures. So these deficit colleges and the government colleges are within the state legislatures, provided the state wish to adopt and implement the scheme subject to the following terms and conditions. So my lord, first and foremost, financial assistance will come from the central government, my lord. Financial assistance from the central government to state governments opting to revise pay scale of teachers and other equivalent cadre covered under the scheme shall be limited to the extent of 80%. So that means there will be 80% contribution from the center, my lord, of the additional expenditure involved in implementation of the revision. The state government opting for revision of pay shall meet the remaining 20% of the additional expenditure from its own sources. The financial assistance referred to in subclause A above shall be provided for a period from 1/1/2006 to 31/3/2010. The entire liability on account of revision of pay scales, etc. of university and college teachers shall be taken over by the state opting for revision of pay scales with effect from 1/4/2010.
What happened on 1/4/2010? And that letter was issued on?
Well, that letter was issued prior to that, my lord.
Whatever it is.
31st. Well, that letter is issued 31st March 2010, my lord.
No, letter was issued 23rd March 2010.
23rd March, yes, ma'am. Financial assistance from the central government shall be restricted to revision of pay scales in respect of only those posts which were in existence and had been filled up as on 1/1/2006. The state governments, taking into consideration other local conditions, may also decide in their discretion to introduce scales of pay higher than those mentioned in the scheme and may give effect to the revised band scales of pay from the date on or after 1/1/2006. However, in such cases, the details of modifications proposed shall be furnished to the central government, and the central assistance shall be restricted to the pay bands as approved by the central government and not to any higher scale of pay fixed by the state governments. G. Payment of central assistance for implementing the scheme. My lord, here is another condition which is stipulated, my lord. Payment of central assistance for implementing the scheme is also subject to the condition that the entire scheme of revision of pay scales, together with all the conditions
without any modification.
Yes, my lord, shall be implemented by state governments and universities and colleges. Composite scheme without any modification except